hold on, Mr. Kravitz? You're on mute. So
I'm all set. Sorry.
All right, the case is 2022 J0726 25 Greycliff LLC versus Maryanne West.
good morning. My name is Marguerite Grant. I'm an Associate Justice of the Massachusetts Appeals Court, and I understand, Ms. West, you will go first, and you can start whenever you're ready.
Thank you, Your Honor. Thank you very much. And also wanted to thank you for letting me have the extra 2 weeks. My brother had died, so it really helped me, you know, gather my thoughts. Thank you very much. I had originally thought at the hearing of the housing court, Your Honor, that an appeal bond had been required, but I found out that it is not, and that is good. So I guess the only question here is about the current use and occupancy payment of $3,500. I had explained to Judge Malamut at the hearing that it is a stretch for me, and I also gave him the reasons why. One of them being that I have a retirement from the city of Boston. I was assistant director of psychological services in the school system there. I worked for about 24 years in the school system. And I did retire at a young age, as I did explain to the judge, which makes my retirement rather low. I retired at about the age of 43, and they were doing away with, they were decentralizing my department. So because I was the assistant director, I had the legal right to retire. And unfortunately, I had applied for an assistant superintendent's job at the time, and my applications were stolen. I had applied for a special ed director, and I was threatened that there was no way I was getting that job. My father was an FBI agent. He was alive.
I have some questions for you, Ms. West. I want to try to sort of focus on the issues that I'm supposed to decide here today. What do you say is the fair rental value of the property? As I understand it, that's not what you can afford to pay, but what a landlord could get for it on the open market.
Well, honestly, Your Honor, I think that it is in the ballpark of what it is now. However, I do want to say that the heat is not included in the $3,500, and I am getting help with that payment of the heat, thank God, through ABCD.
When you say it's in the ballpark of what it is now, what number do you mean?
Well, the $3,500, Your Honor. My house is across the street from Boston College, and so naturally I used to rent it myself, so I know the value of a property across from Boston College would be rather high. So, you know, it's a valuable apartment, let's put it that way. I'm not putting down the apartment at all.
So another question, as I understand it, another question I'm supposed to consider is the merits of any defense that you would raise on appeal. Can you briefly tell me what the merits are of your defense?
Yes, hold on, please. Well, I don't know if the my being able to afford it is a defense, or does not that come into it at all, and then I won't waste time on that one.
Well, I think the issue is the fair rental value. So
okay.
The merits of your defense is
okay. And
why is what Judge Malamut did at the trial back in September, why was that wrong?
Well, Your Honor, this first issue about the $3,500, I was paying $2,200, I believe, up through last April. And that, of course, wasn't as bad as $3,500. And then at a hearing, and I believe it was, you have to check the dates, but at the end of April, well, prior to that, on March 17th, I believe, I was in the court expecting a hearing, and the Attorney Kravitz didn't come, and Judge Malamut told the clerk to call him up to see if he was coming, so we waited for him. And the clerk said he's not here, and the judge said, well, call him again because he's an attorney, so he deserves, you know, whatever. And so he's called him again, and he spoke to Attorney Kravitz again while we were waiting, and he again apparently told the clerk he wasn't coming. So I thought at that point that the case would be dropped because Attorney Kravitz is the one that wanted the use and occupancy raised to $3,500. However,
Well,
the case wasn't.
I can't say why it was that Judge Malamut extended Attorney Kravitz the courtesy of looking the other way at his non-appearance, but I will note that this court gave you a continuance, and it's not because you are not an attorney. It's I think most judges will look to extenuating circumstances that people have in their lives, whether or not the person is an attorney. Another question that I'm supposed to consider, there's a case called King that I'm looking at, is what's the amount owed per month on the mortgage? And I understand this property has been foreclosed on. Is there an amount owed on the mortgage per month?
Well, that's a very complex question. I didn't have an attorney, but I had an expert, a national expert. Her name was Marie McDonald, who I met at the Boston Bar Association. Back in 2010, I took a class with the attorneys about illegal foreclosures, and she worked on my case. And she contacted the then attorneys, Partridge and Hahn. They were located in Rhode Island at the time. And she had sent them a rescission saying that they were going to foreclose, and she advised them.
I understand that the rescission wasn't timely. It wasn't filed timely.
Well, she would not agree with that. She claimed that at the time the law in Massachusetts would allow her to put in a rescission if there was a pending foreclosure. And she, being a national expert, she's contacted by Senator Warren for advice, people like that. Anyway, she did contact the first lawyers, Partridge and Hahn, and advised them to stop the foreclosure. And they did. They canceled it. And I never really heard from them again. And Wells Fargo really wasn't involved. They got the loan from a World Savings Company. And then they didn't come after the house. They didn't question the rescission, this Partridge and Hahn. They have 20 days to go to court, I believe. And that never happened. So that was the first law firm. So they didn't do anything, to my knowledge, about the rescission. So the president of Wells Fargo got the rescission. The lawyers got the rescission. And
well, I understand that the issue about the rescission was already handled. That appeal was already heard by this court back in, I think, 2021. So a little over a year ago. So yeah. I want to try to focus on the issue that's before me. So another another thing I'm supposed to consider is the amount of any real estate taxes on the property. As I understand it, is 25 Greycliff LLC paying the real estate taxes?
Does he want to answer that, the attorney?
That's for you, Ms. West.
Well, they put their name on my house February 2020, and I had gone to an attorney.
Okay. So the other question I have for you is, I noticed both in your motion in the housing court to waive the appeal bond, and then your appeal to the single justice from that, there was a box that you did not check. And that box would be about an assertion that you are indigent, in other words, have no money. And also there's a blank on both forms for you to fill in your non-frivolous defenses. Is there anything you want to tell me about what could have or would have gone in those boxes? Ms. West?
Your Honor, it appears she's been disconnected.
Okay.
Your Honor, I don't mind if we pause and
okay. Do you want to why don't we pause?
Just
And
one
why
moment.
don't you put Mr. Crevitz back in the waiting room while we see if we can get Ms. West?
Thank you, Your Honor.
Hold on, Judge.
Okay. We will take us back live again.
Okay, one moment.
Are we on?
One moment.
Okay.
We are live.
Okay. Sorry, we had a technical difficulty. We are back on, and Ms. West is going to continue her argument.
Thank you, Your Honor. I'll try to summarize. So again, the rescission, nothing was done about that. I think federal law requires that lawyers have so many days to do it, and that happened in 2010. And then Wells Fargo took over whatever loan was left. In the meantime, Marie McDonald had referred me to a reverse mortgage company, Your Honor, and they were located in Massachusetts. The man came to my house on 2 separate occasions, okayed the reverse mortgage. There would have been money left over, and Wells Fargo refused the reverse mortgage, which would have paid off anything. Well, it was around 2013. Everything would have been paid off if Wells Fargo knew enough to accept the reverse mortgage on 2 separate occasions, and that can be proven because the man can be located. He was at Reverse Mortgage Company in Plainville. He's no longer there, but Marie McDonald is very well known. It's McDonnell. She runs a fraud. She's a fraud expert about mortgages.
Well,
anyway,
I have a question for you, Ms. West.
Yeah.
When we got disconnected, the question I was asking is that on your motion to waive the appeal bond and also your appeal to the single justice from that order, there was a box and a blank that you didn't fill in about whether or not you're indigent and whether or not you have a non-frivolous defense in this case. And my question for you is there anything you want to tell me about those blanks on those forms that you would like to say now?
Well, I don't know the definition of indigent. I do know, Your Honor, that I don't know the legal definition. I do know that all my money is going towards the payment, and I have a roommate, a disabled veteran, and he doesn't make a lot. And so most of our money is going towards that, and an acquaintance, a friend of an acquaintance has been helping me out to pay the $3,500. So I really didn't know the legal definition. Maybe I wouldn't come under that with the legal definition, but, you know, most of the monthly money is going towards the payment, which I don't mind because I want to stay in my house. I mind, but I don't mind that much because I have to, you know, keep my residence. So again, I don't know the legal definition. And I'm sorry about the blank. What was that blank that you mentioned? The blank
It was
form?
the motion. It was the motion that you filed in front of Judge Malamut to waive the appeal bond, and it had on it under number 1, the tenant is indigent within the meaning of Chapter 261, Section 27A, and the tenant has non-frivolous defenses in this case, as set forth in the answer, or as follows.
Yeah, well, again, that's the reason that I'm not sure about the I can't say the word. But anyway, as you can see, most of our income, again, because I did retire at a young age. But anyway, so it's not as much as someone that was 65 when they retired. And just to quickly say, I had been threatened that I would not get that special ed job. And my father, an FBI agent, said, you have to retire. And that's it, because they're threatening you now. But I'm just telling you why I did retire at a young age. Anyway, back to this. Yes, I do have what I consider a non-frivolous. Well, I don't. How much time do I have?
A minute and 2 minutes and 20 seconds.
Okay, I believe that the foreclosure was illegal. They put the ad in the Metro, which is a non-circulating newspaper. They called it a circulating newspaper, the lawyer for Wells Fargo, but it is not. I looked it up. The definition of a circulating newspaper is when it has subscribers. That one had no subscribers, but that's where my house was advertised. They sold my house for $775, and yet the top bidder was bidding $1,057,000, so they undersold the house. A woman that was supposed to be advocating for me wrote an affidavit, sent me to her lawyer as to the reason that all different reasons the sale was illegal. It's in the registry of deeds. I can provide it for you if you do want it. And then the same woman, as soon as the affidavit was submitted by this attorney Magato, who, by the way, has been under investigation by the Board of Bar Overseers and almost lost his law license, she then told me to send this affidavit to the top bidder, which was a Russian man who bid the $1,057,000. I refused, saying I can't do that. That's public record, and I don't want to fool with that. And so it appeared that she was trying to dissuade the Russian from buying the house. A couple of weeks later, the same lady told me, "Oh, the Russian has walked away."
Ms. West, you have 1 minute left. You have 1 minute left.
Okay, I don't know. Yes, I don't know why she knew it, but she knew more about my house than I did. She then started talking about a Jay Testa, who she said was a wealthy investor who would pay me $75,000 to move out of my house. And I said to her, I don't know what you're up to, but it doesn't sound right. You try to get rid of the top bidder by using me to send the affidavit to him, and now you have an investor that wants my house. So this went on for weeks. She wanted me to call him. I refused. She then told me that Jay Testa called her up in the middle of the night and said, "You tell Maryanne West if she doesn't take 75 grand that I will sue her." I said, "Well, that sounds illegal." And so then the next day I got a lawsuit from Wells Fargo, and this advocate said, "Oh, well, are you sure it isn't from Jay Testa?" I said, "Yes, I am sure. It's from Wells Fargo." She said, "Oh, well, then he must be paying Wells Fargo to sue you." And that's how the case started in the Suffolk Superior Court. Right now there's a case in Suffolk Superior Court for monies owed from the sale. And it says that my understanding is the lawyer for Wells Fargo was claiming that in that case that Wells Fargo was the top bidder. I don't think that's correct. I don't think Wells Fargo bid anything. Anyway, I don't think it's frivolous. I contacted a consulting lawyer. She claims that the deed is a forgery in Massachusetts. And
Okay,
she told me to go to the...
I think your time is up now. You've actually a couple of minutes over the time.
Okay.
I wanted to let you say what you wanted to say. So we'll turn now to Mr. Krefetz.
Thank you, Your Honor. Your Honor, my client doesn't believe there's any valid legal or factual reason to overturn the decision of Judge Malamut in the housing court, which essentially did not order the setting of an appeal bond. My client waived its claim to an appeal bond and simply ordered that the defendant continue to pay ongoing use and occupancy payments, which she's been successfully paying on the first of each month for a very long time now. Your Honor has a question?
Yes. Why did your client waive the appeal bond after filing a memo in opposition to?
Because the appeal bond, because basically the only loss which my client would be incurring would be if they were not getting ongoing use and occupancy payments. There's no, aside from a roughly $2,000 payment that Dr. West had not made pursuant to some prior court orders concerning other procedural issues that happened in the housing court, there isn't some kind of outstanding amount of damages. So my client was satisfied that as long as the use and occupancy continued going forward, that we didn't need to dive into a whole other pool of litigation over trying to get some additional bond.
You had your pound of flesh.
I don't know if it's a pound, but
yeah,
a quarter pound.
So
anyway.
I have a question for you about King.
Yes.
In King, Judge Shields found that defendant was indigent, and also Judge Shields found that defendant had a non-frivolous issue on appeal. Here, Judge Malamut specifically said he wasn't finding indigency because the appeal bond had been waived. does King apply? At the very end of King, the SJC says, a post foreclosure mortgagor may seek a waiver of an appeal bond if he or she is indigent and has non-frivolous claims on appeal. So that doesn't apply. But then the next sentence says, essentially, I'm paraphrasing, the court shall order a post foreclosure mortgagor remaining in possession of the property to pay rent pending appeal if his or her bond has been waived. So am I correct in interpreting King to mean that even in a situation like this, where the defendant has not shown grounds to waive the appeal bond because she hasn't shown indigence, where the plaintiff voluntarily waives the appeal bond, you could still order use and occupancy?
Absolutely correct, Your Honor, and that was
So,
what we went for. You know, I want to mention that, as Your Honor heard, the defendant, the appellant, admits that she's not indigent. She's admitted that in this hearing, and she's admitted it at prior hearings in the housing court. She assented to the valuation of monthly use and occupancy at $3,500 a month. It was previously set, I believe in 2020 by Judge Bagdoyan in the housing court at a lower amount, but that was in a very, very different market in the depths of COVID. This house has another unit that is being rented out now for $4,900 a month. So
did she own the whole building or just a condo on the second floor?
no, she owned the entire building. And also going into the calculation regarding the indigency is that there's currently an interpleader action in the Superior Court subsequent to her litigation against Wells Fargo, where the issue of the rescission was decided. And this new action is 2284 CV 00341F. And that's an interpleader where the court is trying to give Dr. West over $200,000 in surplus. And instead of going to the court and saying, here I am, please give me my money, she's litigating it. So she's not indigent. She's got all this extra money coming from the sale and is instead just continuing to take up my client's time and various courts' time with frivolous litigation. She has no non-frivolous defenses because, as was found in the housing court, any issue regarding the validity of the foreclosure was precluded by the disposition of the litigation against Wells Fargo in Superior Court. And in fact, my client's litigation in the housing court was pretty much voluntarily held in abeyance by my client while we waited for various appeals court decisions to come down in her litigation against Wells Fargo. And there are, I don't know how many dockets in the appeals court, maybe 5 or 6 about that. So the way I foresee this playing out is she'll continue to pay this use and occupancy, which is well below market. She will continue to bring various appeals in the appeals court. I believe she's, I don't know if it's been properly docketed, but she's at least in the housing court filed a notice of appeal concerning Judge Malamuth's decision not to recuse himself. I just think there's going to be more of this, and my client is just seeking.
I'm trying to keep my eye on the ball here and
Yes, Your
what
Honor.
I have to decide in this case. And at page 51 of King, the SJC says that there are factors that the housing court judge is to consider in setting use and occupancy. In the following paragraph, they say that the single justice should also consider the same factors. And I asked Ms. West a few minutes ago about each one of those factors. And I just want to give you, we've discussed some of them already, but I want to give you an opportunity. There's some that I don't think I have any information on. And I want to just give you an opportunity to tell me anything that I need to know. So there's the fair rental value of the property. We've discussed that. The merits of the defense, we've discussed that. The amount owed per month on the mortgage, the number of months that no money has been paid on the mortgage, the real estate taxes on the property, the expected duration of the litigation. I think I can infer that, how long this case would take on appeal, but you can tell me anything you want me to know. And the respective financial conditions of the parties. We've talked a little bit about that, but I just want to give you the opportunity. You have a little more than 6.5 minutes left to tell me anything you want me to know about those factors.
Yes, Your Honor. So as I think Your Honor is aware of the factors the court has to consider under Davis v. Comerford regarding use and occupancy payments, and those were combed through multiple times in the housing court regarding various motions for use and occupancy payments filed by my client, as well as motions for reconsideration that were filed by Dr. West. And I would say that the issue of Dr. West's indigency, which again, I know she doesn't claim that she's legally indigent, which I think is the only criteria we're really concerned about in the court.
Right.
And she also doesn't dispute the valuation, which again, I submit is below the fair market value. But again, as Your Honor is aware, parties make decisions during litigations and during prolonged litigations as to which battles to fight and which to let lie.
What did you say? You told me that the other apartment in the building was being rented. What did you say the rent is in that apartment?
$4,900 a month.
And is that architecturally similar to the apartment too?
It is. I believe it has a new bathroom and kitchen, which Dr. West does not. All of the carrying costs of the property are being borne by my client. Dr. West is no longer on anything except, I believe she is paying her own, electricity and her own gas. But as far as things like taxes, insurance, et cetera, that's all being borne by my client and has been since the foreclosure sale, which is several years at this point. So, the respective financial conditions of the parties, I would say that, the landlord obviously has a bigger asset, but Dr. West is in the position of a renter, typically at this point, who is receiving a tenant at sufferance, but she's paying use and occupancy and she's receiving use and occupancy. So her, a tenant at sufferance is liable to pay use and occupancy for the period which they detain the property. I think that's 186 section 3. And that's what she's doing. And the use and occupancy, while not what my client would like to get if Dr. West left and they were able to, fix up the apartment a little bit and rent it out to some people who want to live across the street from Boston College, it's, it's been deeply examined by the housing court at this point, what should be paid. And I think that we heard even Dr. West agree that it was a fair number. So whether or not she claims it's some kind of inchoate hardship because she would rather spend the money on something else is different than being in a financial position where you cannot make the payments and you will be homeless if the court orders you to pay. So, and again, I know as Your Honor also noticed that there were no actual claims made on Dr. West's request for review of orders relating to the appeal bond. And she's generally come before Your Honor today and stated the same things that she's said many times in the lower court, almost all of which are irrelevant to what we're trying to decide today here, and were not raised appropriately prior to the trial. If Your Honor has any further questions, I'm available, but I'm asking Your Honor to allow the housing court's order that Dr. West continue to pay her $3,500 a month, which again, she's been paying for quite a long time now, to her credit, on the first every month.
So this is somewhat unusual as an appeal bond appeal. It's a little unusual situation.
Yeah, it's almost like Dr. West is not contesting the lower court's findings, but wants to air her inopposite claims concerning the underlying foreclosure again.
Right. I'm trying to focus on the issue that's before me, but so thank you. That's been helpful.
Thank you, Your Honor.
Thank you both. This was a very helpful argument from both sides, and I appreciate both of your points of view, and have a good day, everyone.
Thank you, Your Honor.
Thank you.
Thank you. Thanks.